Welcome to law lectures. Yeah, it's nice to see your funny pictures on the screen and your names. So my name is Renata Cibulskina and I will teach you law subject this semester, spring semester. I am teacher at Vilnius Tech University and also I am practicing lawyer. So about our course, maybe you already visited Moodle system and you noticed that there are some practical exercises added to the material. You do not have practical exercises, but because it is the same course in the Moodle for other groups which have practical exercises. So the information and exercises are for them an additional material. But of course, you can use it, and I advise to use to go through this material because it will be not a new material, but a material which explains the material we will be discussing on our lectures. So you are free to use this material. So we have just lectures and you will see the day for midterm and we will write a midterm on this day. And according to our plan about lectures, yes, everything should go on remote way until 5th of April. And after the Easter, we should stay with lectures on remote way and practical exercises should be at the university. But I don't know if it will be with your group. So you do not have practical exercises, so we will stay on a remote way until the end of semester. And so midterm we will have on Moodle, and final exam I don't know yet how it will be. I think that it also be in Moodle, but let's wait. Anyway, it doesn't matter where it will be, either in Moodle or in at the university. The exercises will be or tasks for midterm or for final evaluation for final exam will be almost the same. So you always have open questions. Will be no tests. So it will evaluation will be based on your possibility to think what law it is. As I know it is quite hard for students who studies not social science, but I think you are still able to think and can answer not only the test questions but also open questions. So don't be afraid to show what you think, because law is social science, and as you see, it can be a lot of different ways to think about law, and it is the best way to show your own opinion. And during midterm or during the exam, it's better not to copy a material from the internet and to put in your answer where you can find similar words, because it's always very clear where it is your own opinion or where you took from internet. Because usually if somebody finds something interesting and useful to use in the answer for midterm for exam, so others also find the same, and so I got the same answers, almost the same, more or less. And so it becomes difficult to evaluate and to put a grade for such answer. So don't be afraid to use your own mind. You can see in the material for practical exercises with I don't know exactly, and I can't go to Moodle directly, but it's I think the name of these practical exercises is Time for Good Movie. So I really recommend to go there and to see this movie. It's old movie about 12 Angry Men. I think the name of this movie. Maybe somebody already know it. For others, I just recommend because it is it's a good movie, psychological movie about law, about psychology of the people, about litigation in the court, it's about jury process. It will be really useful, and also there are some questions. You can read this questions because maybe some similar questions will be during your midterm or exam. So what we have to do more? Homework. You have to do a homework, and it is in the Moodle. Yes, you can find a task in the Moodle, but I'll share the screen and I show you this homework. I hope you see it. It's very, very simple. And so you have just to follow these 6 steps. First of all, you have to find a case, a court case. Of course, for Lithuanian students, you can find in Lithuanian and translate for yourself to English and do a homework from Lithuanian court cases. But also you can find any case on the internet. There are a lot of available cases. Just not to try to find a case which are described in 5 or 10 sentences, because it will be difficult to do homework. Try to find a case where is a lot of material. Yes. And there are a lot of such cases. You can sometimes you will find summaries of the cases, and okay, you can use a summary of a case, but the summaries are different. Ones are normal summaries, there are a lot of material, and others just few words, so don't use this few words. You can select a case, a legal case, whatever you want. It can, maybe you can find from a case from competition area, where I don't know, some issues with Microsoft and European Union.
Excuse me to interrupt you, but where did you find the homework? Because
Moodle, in the Moodle.
Because in the Moodle there's like a bit different one word uploaded.
Yes. Okay. Okay. I'll try to get to the Moodle and to check what it is. What's the problem is with it?
It's not the fundamental of laws, right?
Oh, here. No, it's not. Fundamentals of law, it's not a homework. It is material. It's like summary of the course. It should be another file with like assignment. Okay.
It's there. I just found it, so it's in the Moodle.
Yes.
Bonus is the first thing on as soon as you press.
Yeah, thank you.
Okay, so I always try the most important things to put the first, because I know that all students are very smart students, but sometimes, yes, it's difficult to find information. Okay, so let's go back. I stopped sharing. Okay, so just a moment. No, it's always problem. I try to go to stop share. Okay, once more. Okay. And I try to go during Zoom to Moodle. It's not so easy to get back. Here we are. So you really will find a lot of different cases. It can be, as I said, criminal case. It can be private case. It can be some from competition, maybe EU law, maybe from the case from human rights topic. Whatever you want. The task is designed for you to try to analyze the case. So it doesn't matter in which area you will choose this case. I suggest you analyze using these steps. Of course, you can do it in another way, but just I think it will be useful. The final goal is to make a presentation, PowerPoint. Let's say presentation. You can use another program, but maybe it's the easiest way. It should be 15-20 slides. You should do it independently. One student, one homework. Because it's not clear, are you will be able to present orally? If we still have time for it, I think because you do not have practical exercises, we do not have a lot of time for presentation. So please try to put more information on the slide. I know what slides should be not a lot of information when you are presenting orally, because too much information is not good, because nobody is able to read all information. But I will be able to read this information because I find time, and I really will read all information you put on the slides. And so don't do in this way, just 1, 2, 3 words, because it will be not clear. Do you understand this case or not? It should be clear for me that I will be reading your presentation, that you understand, and you can explain in simple words, or to put information on slide in the way that it is simple, not just you make copies from sentences of a case that you found in the internet and just paste to the slide, but make your own explanations, may also present your own opinion. It should be your own opinion. You do not need to make a copy of a case on the slides. And so how you are going to create your own opinion? So follow these steps. First of all, you need to think about facts. What are important facts, relevant facts in this case? Yes, who did something, how did, so what are the facts? It's not about legal rules, but about facts of a case. Because maybe some facts are more important, some are less important, but still you have to find what you think are the most important facts, and we have to know about this case. So facts or circumstances related to these facts. So for example, if we have about crime, so how the crime has been committed, if it was murder, so how it was committed, when, who noticed, and so on. So it's real facts of real life. So you identify these real facts and put on the slides. So second, you have to identify what is the problem. Why this case it's on the internet? Why everybody is discussing about this case? Because if the case is not important, you never find it on the internet. Maybe if you go to specific legal databases where you find all decisions of all courts, for example, for Lithuanian courts. But if you will be doing search on the internet, you will find only interesting cases, important cases. Why they are important? Maybe they created judge created a new rule. Maybe the situation was so unclear that nobody really believes that such a decision can come from the situation. So maybe the situation was maybe raised some issues, new issues in our society, and before this case nobody even speak about this issue because nobody knows that such an issue exists. As for example, 10 or 20 years ago, it was a big issue, a big problem, marriage of same-sex partners. Now it's not a big issue, but still you can find a case with such an issue. For example, partners were trying to register their marriage in a country where it's not so easy. So we have a court decision about this issue. It can be one issue, can be more issues. You can divide this one big issue to a few smaller things. So this question, it's the third step. Yes, identify the key issues and problems. So it's already related with law. So the law should answer somehow to these issues. Yes, you can do it as a question. Yes, this issue, and it should be a question where you can ask just no or yes. So the all problem should be in this question. Yes. So step 4, now you have to find, okay, it was an issue, it was a problem. Yeah, so you already described this problem. And now you have to answer how the judge answered to this problem. What decision was? What do you think about this decision? Is it good or not? Make your own opinion. But first of all, you have to find exactly what it was opinion of a judge. Yes, what was decision of a judge, and what the judge thinks about your problem, which you identified. So 5 steps. You have to tell why the decision has been made in that way or not in another way. So the judge thinks that according to the law of rules such and such, yes, the decision should be in this way. No, make your opinion. Maybe you agree, maybe you disagree. Okay, maybe according to the law it's good, but you think that it's not moral thing. It's big. It is big injustice. So make your own opinion, but you should first of all you should explain why the judge made such an opinion, because in the law area you cannot base your own opinion as a judge. Just I think it should be in this way. No, why you think that should be in this way? Because there are legal rules, because there are legal precedents, because it is maybe it is no rule on this question, but according moral standards. So the decision should be based on something, and you should tell on what is based this decision. And yeah, talk about this decision. Do you think if you were a judge, maybe you decided in another way? Maybe you think that it's okay, it's according to the legal rules, but justice was not served, so it's not according to the justice. You need to, you think the decisions should be made in another way, and of course tell why you think. So it's like essay, and of course you can do without PowerPoint presentation, just on the page, on the list of paper, but it will be more easier to do it as PowerPoint presentation. Do you have questions related to your homework? Due date? It's a good question. I can't remember, but it is in the Moodle. When you find where you find this assessment, you will find the day. I think it should be somewhere.
4 April.
Sorry.
4 April.
Oh yes, yeah, it can be. Yes, because
Yes, we have 60 days to do this homework.
Yeah, you have a lot of time, so
we don't have a lot of time because we have bachelor thesis also.
Just please not leave until the last day before the exam, because any time to read it, and it's not so easy, because I'm also practicing lawyer and work not only at the university but at the big law company. So, please do not create problems for me, because I can create problems for you. Okay.
Yes.
Okay, you can make your own decision. You can, let's say, I think that the decision will be in this way, because it is such and such.
Yes,
and,
but
okay,
should it be a case in Lithuania or anywhere?
It can be, you can take a Lithuanian court case. Just when when you find information in English, it will be.
Yes, but I mean, it must be from Lithuania, or it can be.
No.
Okay.
So it can be any country.
From any country, anywhere. Because in Lithuania you do not find a lot of cases in English. Maybe you find few only cases, and maybe they will be very short with information. So really, and Lithuania is a small country. Usually we have also small cases, and if we have big companies operating in other countries, we usually have a lot of disputes, interesting disputes, and the outcome of this dispute, it is interesting for people of all countries. So you can find a lot of information on the internet on these cases. So just try to find the case where it is a lot of information about circumstances, about facts, about decision. Okay, if it is not yet decision made, but it's plenty of information, and you can make your own decision. What do you think?
Which sort of case should we pick?
I don't know. It's up to you. It can be private case. It can be criminal case. It can be a company, for example, have a case with European Union institutions. Maybe the case cartel case. It's from competition area. Maybe company abused dominant position so got a fine from European Commission, yes, as it was with Microsoft or Google. Maybe it was famous criminal case. You will find information. Maybe I don't know, somebody made financial crime.
Can it be a murder case?
Yeah, murder case. Yes, it can be. Anyone area. It's up to you. Because
so it doesn't have to be related with tech. Just about any case is possible.
Any case is possible. Because your subject is law. So which area of law is the most interesting for you, and where you will be able to find a good, interesting case, which is interesting for you. Because first of all, when you read a case, you should understand it. Yes, otherwise it will be difficult to do presentation. If you read a case and there are only unfamiliar words for you and you can't understand what the case is about, because really there are such cases with a lot of technical information which are not from your field, so it can be difficult, or sometimes they are written in a very legal English and you can't understand. So try to find a case which is interesting and which is understandable for you. And
as I understand, it's only PowerPoint slides we should present.
Yes? I advise you to use it, but you can do in your own way. I just put the PowerPoint so that you would understand how much information should be. So if you do not want to use PowerPoint presentation, you can use another program, or you can just write as essay. Just in this case, try to separate some, not to write on one page and without separation, so separate. So the relevant facts are, so make the facts. So the problem is, the answer for a problem is, so try to make it understandable, because I have problems when students make all in one piece, and so you can't find where is argumentation, where is real fact, and where is the opinion of a student. And when you use PowerPoint presentation, so you usually try to make it easier to understand to anybody who reads this presentation. So just for this I put PowerPoint. But if you will be able to create something understandable, not only just sentences which are not connected with each other, so you can use another type of form of your homework. You are totally free, yes, to choose a form. So I think it's clear. So you can always ask a question about your homework during lecture time. Maybe you will find a case and something will be unclear to you, so you can ask. Just please do not write an email and ask, okay, I found the case. Teacher, please read this case and please answer my questions, because it takes a lot of time. So it's better to do it during lecture time. Explain. Okay. Okay. So let's go to our slides. I will use slides. You also have this summary, yes, about our course, some main things. But also I will use slides, and I will upload slides maybe in 1 or 2 weeks, and I will make these slides in 2 pieces. let's say it's one material for midterm, another material for exam. So we have the course divided into two parts. That's one part for midterm, second part for the exam, but it does not mean that you have to forget everything you learned until the final exam. But yes, the course will be divided into two parts. Okay, so no more slides. Our Department of Law, it is in Business Management faculty. If somebody wants to find where our legal department is, but I think you do not need, because everything is in a remote way. So here we can see evaluation. Also, you have in Mano VGTU, as the homework is not a lot of ways to your final assessment, to your final mark, but you have to do it, and you have to get at least 5 from it. Yes, the highest mark is 10, and you at least have to get 5. It will be not difficult, just as I told, not to make totally copy of the material of the internet. Please make some your own thoughts on the matter. Additional point for activity can be added. What does it mean? It means that maybe really you made a perfect homework and you invested a lot of time, and I can understand from the presentation that it's really good thing. So I can add this point to final grade. Because usually we use this additional point for activity during practical exercises, but unless you do not have practical exercises, so I can add if you really make a good homework. So it is additional point will be added not to your homework mark, but to the final mark. As for example, your homework mark is 7, midterm 7, and final exam 7, and for example, 1 additional point. So, and your total evaluation, I think it will be 8, because you will get this additional point. Okay, I think that's all about organizational things. About questions, you always, there are not a lot of students in your group, you can always ask during lecture if you do not understand something, if you do not understand my perfect English. Yes, you can always stop me and ask the teacher, what do you mean? Also, you can ask questions at the end of a lecture. You can write in the chat. It's up to you how you will use this right to ask. So you can see on the slide that there are really a lot of description what law it is and why. It's not a mathematic, it's not a physics, where we have, let's say, universal rules of, for example, of gravity, and everybody understands it, okay, more or less in the same way, at least basic things. But law is social science, where everybody has have their own opinion, and we have a lot of philosophical theories, and so we have a lot of different law theories, and you always can look at the law from the different point, from different sides, and so you can understand law differently. Then, but you should understand that we can understand law very differently. We can describe it, what it is, very differently when we are speaking about law. Yes? But then the things is about how we do recognize law in real world, how we recognize it practically. It's really the, let's say, one description. It is a rule which you have to follow, otherwise you have some consequences. Yes? You always can have different opinion why this rule has been created. Is it a good rule? Is it according to the moral standards or not? What this rule, how this rule was created? Was it in 200 years ago? How this rule will be in 2 years in the future? So you can always think about this in different way. But when we talk about implementation of law, when we talk about how we recognize law in our real life, so it is much simple. It's very clear. It is a rule which you have to follow, and state guarantees that you will follow it. Otherwise, negative consequences, and the state will enforce these negative consequences on you. And usually we recognize law according with features. That's because if we have moral rule, so maybe I should go to the church dressed not in very inappropriate dressing. Yes, it is moral rule because will be no legal consequences if I do not follow this rule. But if it is the rule that I should pay the taxes, we know it is legal rule. Everybody knows it, because if I do not pay taxes, so I will get a fine from the state. Maybe I will get arrested. It's different countries have different negative. So we can recognize what it is law in real life very easy, but to think about it, we can in very different ways. And for example, this definition, a system or collection of such rules, of legal rules, as it is what we see in real life. And the first definition is about the principles and regulation established in a community by some authority and applicable and so on. So it's more from philosophical perspective, and it emphasizes one of possible theories of law, because others can disagree that it's not about authority, about natural things. It comes from God and so on. Okay. So we have very different scientific theories about law, and just a moment, because my computer.
Miss, is this PowerPoint on Moodle?
These slides, yes, they will be. Okay. I will upload, but they are not yet in the Moodle. But I will upload in week or 2 weeks. Okay. Just a moment. So we have different legal theories. We have, for example, the main two theories is about positive law and natural law. So it is very different opinion or positive opinion on law. For example, positivist theory, they identify law with the rules which are created by state, and it is the way we recognize law. And they say that everything what was created by state in the process of legislation, it is a law. It doesn't matter, is it good law, is it bad, is it moral, or is not so moral. The law does not care about morality. Okay, we understand that morality exists, but it's not the area of law. Maybe it's morality or moral, or some rules are moral or not. It's the area of ethics, of philosophy, but not the area of law. Because the state has a power to create a law, and this power comes from constitution. This power comes from all people, from nation of that state, because they elect parliament, and so the parliament, for example, has constitutional right to create legal rules for us, and whatever they have created, so whatever is law. And you can't discuss about morality from positivist theory of law. Natural law, it's oppositive theory, and the scholars think in very different way. They say that first of all, law should be based on morality, and we have to find what is moral, what is good for the people, what we have, how we have created the rules to make people better. There are different theories in this natural theory, because one scholars think that we should find this morality, this background for law, somewhere in the mind of the people. Others say it is the will of the God. God has created this law or morality for us, and so the state should just write this law, but it should be based on this morality or will of a God and other opinions, but it is always should be based on morality. And natural law, and we have as example human rights conception. Now, why we have human rights? Because we have all born as humans, so we have all these rights. Yes, and it's the basic postulate of natural law. And it's not the state who has created these rights for us, as we already born with these rights, and the purpose of the state just to guarantee these rights. And of course, in our days, in modern states, usually these two very different legal theories goes together, and everybody understands that okay, the law should be created by the state. Otherwise, we don't know who is law, who is not law. Yes. But it also should be based on morality. Maybe not in degree that only moral things can be in law, and if the rule is not moral, it's not a law, but it should be based on human rights, should be based on morality. So these two basic streams, two different theories, they goes together. But still they are different. And of course, there are a lot of other theories, for example, historical theory of law. So from historic they look at the law from historic perspective. And they say there is no universal law because rules depends on society, on the historical circumstances of particular society, of particular time. The law is different 1,000 years ago and will be much more different in the future. And it is different in different areas. And they focus their attention on the history. And so from the history, we try to understand why we have such rules today, yes, and what rules are before. The law is the science who has one interesting feature, that it analyzes not only what exists now, what rules are now, but also always try to explain how to make these rules better. Yes, usually it's different from mathematics or physics. Yes, because in physics you do not think about how to make physics laws better, because they are as they are. So they are not created by humans; they are created by nature. Yes, but in law, yes, these rules are created by humans, by human mind. And so it's possible always to improve them. So the law always thinks about what it is and how to make it better, as to fulfill and to serve humanity. So historical theory. There are realistic theory which says, okay, you can write rules, whatever you want rules, but real life is different. And real law, it is law which is created by judges deciding cases. Yes, because what is written on the paper, it's just written. But when you have to solve a real problem, so you have to go to the court and the judge will solve the problem, and this decision and how he applied this legal rule, how he solved the problem, it is real law, not just a legal rule. So it's a realistic approach to a law. And there are more different approaches. And in the practical exercises, you can find when one topic is for this question about positive law and natural law. So there are two materials, two pieces of material. One about positive law, about this theory that only state can create a law, and another about natural law, that natural law already exists somewhere in the mind, in the human mind, in the God's will, and state just have to write down this. So you can read the material. So, but when we talk about purpose of law, it is quite clear. It sets a standard of behavior, yes? And the standard is enforceable, and it is different from non-enforceable moral things or ethic things which are not enforceable. System of law. It's so we already discussed. So I explain what I think about law and what other things about law. And now we have a topic about system of law. System of law, I mean that not only legal rules or a body of legal rules, but also institutions who are related with creation of law, with implementation of law. So, for example, it can be prosecution system in criminal cases, as we have prosecutor who make accusation. We have court system. We have somebody who has created legal rules. Sometimes it can be state government, parliament. Sometimes it can be court. So we talk about all the system, and every state in the world has their own legal system. You can't find a state without law system because maybe it is one of the features of a state. Yes, because state has sovereignty, has power to create rules for his territory, and so it always creates a system of law. So it creates legal rules and it creates institutions as who are enforceable, who has to care, yes, about enforceability of these rules. And we have more than 200 states. What does it mean? It means that we have more than 200 systems of law, different systems. But because states are in some areas, they have similar historical backgrounds, similar circumstances. They have, I don't know, similar, some other similar things, territory, climate conditions, and so on. And so we can group these systems in 6 or 5 major groups, and we can compare a little bit because it is difficult to evaluate every legal system in every world. But if we know that legal system of this country belongs to one of a group, we already know some basic features of this legal system. Yes, we can tell, okay, if it belongs to civil law group, so it means that state usually creates the rules. The judges is not so free to decide and to as they want or to create their own rules. It will be not a lot of interesting precedents and so on. So you can already make some presumptions. Yes. And so if you know that this country belongs to common law country, okay, you know that there are not a lot of law created by state, statutory law, but you will find a lot of court decisions, a lot of court precedents. You will have different system in the court. Yes, you will have a jury system and so on. And we will analyze a little bit all this system. We will focus our attention on 2 major systems of law, common law and civil law, because most countries usually have one of this system, sometimes mixed system common law with civil law. Some have, for example, Nordic Europe countries, they have civil law with some additional features, historical features. Socialist law, it's almost do not exist anymore, but it was very, very different legal system. So we put it in different group. And maybe some features of socialist law China still have in some areas, but not a lot. And of course, the religious legal system, which are also not in a lot of countries, but they are very different. So we have to speak a little bit about them. Also, we have international law. It's not a national. Now we speak about national systems of law which exist in different states. Later we will continue on international law, on EU law. It's a system which relates not to only one national system, but international law to all states, EU law to only EU states, but it is different systems. So, despite the great variety, yes, we can group for example, we can do two groups: religious and secular legal system. Yes, religious legal system, they are based on religion. Secular legal system, they have nothing to do with religion. They have law system and they have religion system. They are different and they are not connected with each other. But for example, in religious legal system, as the law is based on religion, or sometimes it's not only based, it is the same. For example, Sharia law in Islamic countries, as it's two in one, as religion and law. And of course, in some countries it has big influence on law, in some less, but they are always connected with each other. In some countries we have a dual system. We have religious rules, and we have religious courts. And for example, they solve such matters as marriage, divorce, family relationship, sometimes family property. While we have a secular system, another system in the same state, with state courts cover the wider fields of public and commercial law. For example, agreements, contract law, it's already in another system. For example, it was such a situation in England until 1950s, until the middle of 19th century. Yes, we have religious courts and we have state courts, and it's the case today in Israel, India, Pakistan, in some African countries, as and these areas are ruled by local ethic and religious customs. Mixed system, they influenced by both civil and common law, and it depends on historical traditions. And for example, the older uncodified civil law of Holland is the basis of the of Roman Dutch law of South Africa, Zambia, Namibia, Switzerland, Botswana, and we also have a common law system which came from England, from Britain, yes. And we have a long contacts with Britain, and so the public law and system of court procedures are much to common law. So it's the legal system have features of both common law and civil law. In some countries, we have multiple legal systems. For example, Australia has a uniform common law system based on English common law, yes, because it was a part of British Empire. Yes, but Australia is a federation, and so they also have the local legal systems, similar to United States of America. Yes, because it is federation, they have federate legal system, and we have states. Every state have their own legal system, and so a lot of other countries, yes, we have not one legal system, but a few legal systems. Canada has usually mainly have common law system, but they have one area, Quebec, which has a civil law system, and it's very different. In South Africa, yes, we have a mix of civil law system, a common law system, and African customary law. So everything is mixed. Socialist law, as I said, it was the USSR and its satellites, another socialist states, and it was quite interesting legal system. And let's see, one of the most interesting things was that they almost do not recognize private ownership. Usually, we can't understand how can law system function without private ownership. Yes, but they try to eliminate private ownership. Of course, it was not very successful because the history proved that the people like ownership very much, and they can't live without private ownership. But the legal system tries to regulate. For example, Lithuania, as former socialist country, of course, 25 years ago, we had this socialist law system, and for example, it was a very interesting rule: one family can have only one house, because one family can live only in one house. If something happens and the family, let's say family, it's husband and wife, and let's say one of them, wife or husband, receives by succession, for example, grandmother passed away, so it was succession, grandmother has a house, and now this house belongs, because of succession, because it was no other heirs, to wife. Yes, and now the family has two houses, and they have to sell one of the house. It was written in the law, and because it is in the law, it is law rule, and if you do not follow, you have consequences, and the state takes a house from you, yes, sells this house, and you will get money from this, but not the house. It was not allowed to have two houses. So it's a feature of socialist law because they try to eliminate unsuccessfully private ownership. And now let's go to common law and civil law system, because we have a major systems, and we will focus on them. Of course, almost both legal system, civil law system and common law system, have the same background. Just historically, we have different historical conditions, and so they made different way, and they involved in different system. But of course, both of them were based on Roman law. As almost all our Western civilization is based on Roman law, so it's both system. They have background in Roman law. Just civil law has more features of Roman law, and common law. In the best example of it is United States or English law. First of all, English law, because English law came to the United States. So they developed in different way, and because he had different historical conditions. So the roots of civil law system, it is Corpus Juris Civilis. It's the name of Roman Emperor Justinian, I don't know, Justinian, I don't know how to pronounce correctly in English. But this emperor decided to organize all rules and all commentaries of the rules of whole empire to one piece, codex, Corpus Juris Civilis. It was the result. It was comprehensive reduction of Roman law to a single written text, because some rules were written somewhere, some was customary rules, and so the emperor organized everything in one written piece, single written text, and it was divided into basic sections. As all these sections are almost the same as we have now. For example, it was about persons, family law, about things, property law, about obligations. It is background of a contract law and torts. And so more or less we have the same divisions in our law systems. So everything started from Roman law. Later, it was a huge influence of canon law of Roman Catholic Church. Beginning in the 19th century and continuing through the 16th century, so we have 4 centuries with big influence of Roman Catholic Church, because Church has a big influence everywhere, and of course it is true to legal system. And second step, of course, there are a lot of more things, but I just try to mention the basic things. We have lex mercatoria. What does it mean? Or law, we can also call law of merchants. It is the other key of development of medieval period. We have a lot, especially in Italy, we have a lot of independent cities. As in every city, were very strong cities with their own law system. Let's say not law system, but legal rules how to make a commerce between merchants. As how to sell things, how to buy, where to store things, what to do if a product is not good, and so on. So they started, let's say, law merchant. as lex mercatoria in Latin, and it was very difficult, yes, because every city has their own rules, and so when merchant arrives in one city, he has to clarify what are the rules. When he comes to other city, he have to find another rules, and so they tried with merchants. They tried to unify these rules, yes, and to make them similar in each city, because otherwise it's the same as in our days. If you want to make a deal, if you want to make a commerce, if you want to sell something or to buy, and with a company who is in different country, you always will have difficulties because you do not know the law of other legal system, as of other country. So you need some maybe international private rules how to make a commerce. So the merchants, they have created such a rules. They were mostly they were not written, they are customary, but every merchant knows these rules, and they became more or less the same in every city. And these rules on commerce, they later came to civil codes or commercial codes or business codes to modern states, and they are used to regulate commerce in our days. Let's say it was the background of business, yes, of contract law, of rules how to do business. So this Roman law, canon law, lex mercatoria, and the last thing, let's say, in continental Europe, the last point in evaluation of civil law system, it was Code of Napoleon in the first years of 19th century. Yes, and it was not the first, let's say, civil code, but it was the famous, the most famous civil code in Europe. And a lot of countries, it was very modern rules in this time, very suitable for all states. And a lot of states, they took the basic things from this Napoleon Code and implemented in their legal system. And so we got this civil law system, which is based on which is based on rules created by state. And usually in this legal system, we have large books of rules, and we call them codes, as they are, let's say, in one area, all rules are made in one piece. It is easier to find them, and so it's a feature of civil law system. So the major features of this system, yes, of civil law system, which has almost all European countries, yes, except England, Britain. Yes, we do not have such a civil law system, and we are not a Europe anymore. Yes, we are island. So the European countries always have law organized in systematic written codes, so big pieces of law rules, and legislation is made by parliament, because parliament has a power to create rules, and this power comes from constitution. So usually all these systems have as a background for the legal system constitution. As it is written act, and all basics, all backgrounds of all legal system, they are in constitution. And only the all other laws, they are subordinate. They should be how to say, less important than constitution. As constitution is the most important act in civil law system. Of course, there is also judge-made law, or we call it precedents. In some cases, the judge also can create a law, but this he has very small area where he can exercise such a power. Only in a few cases where there is no legal act created by state, and the judge have to solve the situation, as he can create a law rule itself. Because civil law system is based on law created by state. And usually he can exercise this right in private cases, and in criminal cases everything should be created by the state. As for example, in Lithuania we have criminal code, and all crimes which let's say all actions which we can call as a crime, they are in this criminal code. If this action is not in criminal code, it's not a crime. Yes, it's all actions, the worst actions, the action which has worst consequences, we call them crimes. So, and they are in this criminal code, and the judge can't create a new rule and can't tell, okay, I think now that this behavior is not good and it is crime and you will get a criminal punishment. No, the parliament should pass a law and criminalize these actions, and just only in this situation we can call this behavior as a crime. Yes, it's example that the state has, let's say, state institutions has priority in creating law rules. Common law system. Yes, it also have a background, of course, in Roman law, but it involves very differently. If in civil law, in medieval times, in civil law countries, yes, the scholars, they took Roman law and they look for the rules, and they were adapting these rules. They read that, okay, the agreement should be concluded in this and this way. Okay, now we have a little bit different situation, so we should adapt a little bit. So they write commentaries to these Roman rules, and so the system evolved in this way. But in common law system, there was no such commentaries, and the common law tradition emerged in England during Middle Age, and it also was applied in British colonies. And the main creators of English law were English courts, and basic common law rules emerge from the changing and centralizing powers of the king during Middle Ages. And after Norman conquest in 1066, medieval kings began to consolidate power and establish new institution of royal authority and justice. And new forms of legal actions established by the crown functioned through a system of royal orders. And these royal orders, they provided a specific remedy for a specific wrong. So they created new system, and the system of such writs became so highly formalized that the law of the courts could apply based on this system. And so the courts, they applied these writs, these orders of a king, and so they created new rules. So the special courts, they created new rules, and so the system involved in a different way. And now common law system is the system of all English-speaking countries, because all English-speaking countries usually they were colonies of British Empire. And so they adopted the legal system, common legal system. The main features of common law system. First of all, common law is based on precedent, so on the decision of the courts. And what does it mean, precedent? It means that once the court has created a rule, another court should apply this rule in similar circumstances. And sometimes it can change this rule. For example, we have situation in our days, but the court can take a court decision which was made 200 years ago, and can, in similar situation, but because situation is a little bit different, because time is different, he can adapt a little bit this decision to our day's situation, but still the essence of this decision, it will be the same. So the common law is always based on precedent, and it's a really interesting thing. And law system, rules of law are much more interesting than in civil law, and all cases also are more interesting because you always can find the background. Why was such and such rules, such a rule? So 500 years ago it was a rule, 200 years ago it was adapted, it was changed a little bit, and now 100 years ago it's also one more change was made, and so we have a rule today in this way. But we can find a background 500 years ago, and it is interesting, and not so interesting in civil law system, where just why we have such a rule of law. Why? Because state or parliament has created such rules. Why such a rules? Nobody knows. Maybe just somebody thought that it's good. But in common law system, you can find the roots, you can find the backgrounds of each rule, because it is based on decision on the courts, on a precedent. So this decision, they bounds judges and they should apply them. And usually common law system countries, they do not have written constitution or codified laws. But of course nowadays, because even some countries which have common law system, they adopted written constitution. But earlier it was not the case. England still do not have written constitution. Also codified laws, it's not popular in these countries. They have legal rules in different acts, not in one piece. Very useful feature of common law is predictability. Of course, there is equal treatment in like situation. Yes, and it's possible because we have court precedents, and which mean that in similar situation you should apply the same rule. So it means that you have no possibility as just equal treatment in similar situations. But another feature is predictability, and it is very good in, for example, in business world and in everyday's world, because you know exactly what the rule is going to be, for example, in next 10 years, because the judge can't change dramatically the rule. Yeah, it can adapt a little bit the rule, yes, but it's not a power of a state just to create completely new rule, yes, as it is in civil law country. Yes, it should come from court precedents, from some backgrounds, because state has limited possibilities to create new laws. But of course, you have to understand that in nowadays, in modern states, also, of course, state has possibility to create new laws, but not so much as it can in civil law legal system. And for example, predictability is very good in commercial relationship, and it is the reason why companies use English law or common law system in contract law. And it's because everybody, it is stable system of law, because it was created a few hundred years ago, and almost all the same rules exist now. And Lithuanian, for example, contract law, 25 years ago, we have different legal system. We have socialist law, which is completely different from what we have now. And if you look at, for example, contract law, it was completely different rules. And so nobody knows how it will be in 20 years, after 20 years in the future. Yes, because it's possible to change legal system because the state change legal system. It's the state creates system, and it's not so possible. It's not possible to change legal rules so quickly and so dramatically, so completely in common law system. So it has this system, common law system. They have predictability. They are stable system, and especially in commercial relationship, it is great value. That's because if you create an agreement and you made an investment, and you know that the agreement, it will be for 50 years, and so you need to have a stable system in order to make these investments. Okay, we should stop for a moment, because for now, not for a moment, because our time is running out. Do you have questions? No questions. Okay, so let's meet next week, the same time. Thank you for participating, and have a good.
Thank you, Professor.
Thank you.
Alright.
Have a nice day.
Take care.
Bye.
Bye.
Bye.